Thank you for joining us for another episode of CF on Cyber, the podcast for executives who want to cyber-proof their businesses. Today, we're going to discuss cyber and privacy due diligence best practices for private equity investors, what they should look for, where to look for it, and what can go wrong if cyber due diligence fails. We're going to hear from Jack Clabby and Joe Swanson. Jack and Joe are attorneys in Carlton Fields' Tampa office. They are both former criminal assistant U.S. attorneys and computer hacking and intellectual property prosecutors. Now they represent companies, executives, and directors in investigating data loss events. They also handle securities and corporate governance litigation as well as white-collar criminal matters. Now, I'll turn it over to Jack and Joe.
This is Jack Clabby from Carlton Fields, and thank you for joining us on CF on Cyber. We're here today because we've had, in the last 6 months, a couple of engagements with private equity firms and a lot of conversations about the role that cybersecurity has when private equity and other pooled capital is thinking about making an investment in a company. And Joe Swanson, the practice group leader here, is here to talk about this because he's had these engagements, and his perspective hopefully will be instructive both for private equity firms that are making investments where cybersecurity is important, but also for those companies that are getting their cybersecurity readiness in place for a potential investment. Thanks so much, Joe.
Thank you, Jack.
All right, Joe, to get us started here, why is due diligence into the cybersecurity practices of a target company so important?
Thanks, Jack. I think a recent example, sort of ripped from the headlines, really underscores the importance, and that's the Marriott Starwood. Now, it was an acquisition, not a private equity investment, but it proves the point about the importance of cybersecurity due diligence, and we'll get into it in a bit more detail later on, but as I think most listeners are aware, Marriott acquired Starwood, and unbeknownst to them, because their due diligence did not pick it up, Starwood had experienced a significant data breach, and that became Marriott's problem upon closing that transaction. And so, I think there's a realization, certainly in the private equity world, that potential investment targets, their cybersecurity and privacy posture have a significant impact on the success of the investment. And these are increasingly issues of importance to all companies, regardless of industry.
In some of the industries, in particular, where we've seen action, I know, are when there's specialized data that's a part of the business model of the target company. It might mean it's an online business model as well, where there's an operations component that has to stay working, and when the connections fall, there's some serious problems and exposure. Software as a service company is one example. A cloud provider is another. And then the type of companies that hold this data, right? Think about a hospital group that has HIPAA data, or an online retailer accepting credit card payments has to comply with PCI. Joe, when a lawyer like yourself gets involved in aspects of private equity investment due diligence, what does that engagement look like?
Sure. So it typically would begin with a call between the firm and the private equity client to understand where they are in their due diligence process. How big is the investment? How big is that firm's stake relative to other investors in that round? And how aggressive does the client want to be in terms of asking about and following up on these issues? After that scoping call, Carlton Fields would prepare a set of written due diligence questions focused on privacy and cybersecurity that would be designed to elicit both written answers as well as the target company providing documents that could be reviewed that are relevant to this topic.
And when you're providing those lists of questions or those lists of information requests, what are you looking for, both with those questions, and what are you looking for in the materials that get returned?
Sure. So on the security side, you're going to be asking for and looking for any documentation related to any data breaches or even incidents short of a data breach. One, how many has the organization had? And if they have had them, how did they respond? Were they diligent about it? If it exposed certain flaws in their infrastructure, did they address those? All of that would be of great interest in doing the due diligence. Also on the security side, you're going to want to see what kind of policies and procedures the target has in place. And most notably, do they have an incident response guide, which is the playbook that the organization is going to use if they detect any type of a data security incident, how they respond to it. That's going to be spelled out in the incident response guide. And whether there is a guide and it has been practiced and socialized within the organization ought to be of great importance to the private equity firm before they make their investment. The other big item you're going to look into on the security side is whether the target organization has to comply with any industry standards. You talked about PCI a few minutes ago, Jack. Another one would be the CIS framework. Do they adhere to any of those compliance frameworks? And if so, how diligent are they in tracking their efforts?
So, Joe, that's security posture, but what are you looking for privacy?
Sure. So privacy is increasingly important with the European Union's GDPR and now with California's Privacy Act set to take effect. There you're looking for, is this an organization, the target, is it an organization that collects consumer data? Does it process that data? Where does it hold that data? How safe does it maintain that data? And if a data subject, or an individual, an employee, a consumer, were to ask that organization for a copy of their data, how easily could that organization comply with such a request?
My guess is that we know from talking to a lot of companies that are subject to California's new data privacy statute that, if those companies were going through a potential strategic investment, they would have some challenges, perhaps proving that they were compliant, right? This CCPA is significant. It's going live January 1st. It provides a private right of action. So, the plaintiff's bar is out there looking at different companies, and what you don't want to do is have a private equity firm make an investment, put some people on the board, and then suddenly they've inherited a new lawsuit under this CCPA. Does that bring up cyber insurance? Something like that, right? That might cover a lawsuit related from it. Is that something you look to too?
Absolutely. As part of the due diligence, you're going to ask whether the target has cyber insurance, and if they do, what did the application look like? What kinds of representations were made to the carrier or to the broker? That's going to answer some of your questions on the security side. And then you're just going to want to have a sense for how much coverage is there and what types of things does it protect against.
So if you're looking at security posture, you're looking at privacy, you're looking at cyber insurance, what does your assessment look like with respect to the actual people who are involved?
Yeah, no, and it's important not to overlook the key role that the personnel are going to play within the target. And so you're going to want to get a sense for the security team. How experienced are they? And who do they report to within the organization? Do they have autonomy within the organization? Do they report to IT? That can present some challenges. Or do they have greater independence and report up to the C-suite and make regular updates to the board? Those are things that you're going to want to get a sense from, and you may not really have a feel for until you speak with some of these people directly on the phone or in person. The other thing you're going to want to get a sense for, both in the written materials as well as in any follow-up calls, is what kind of attention does the board pay to cybersecurity and privacy? And you can get a sense for this by asking for the minutes, by looking at presentations that have been made to the board that have to do with cybersecurity and privacy, and also just asking about the cyber expertise of the directors.
So in this life cycle engagement, you've asked some questions and sought some information. You've now seen the documents and seen maybe some Q&A or some written Q&A back on the posture and the privacy, the insurance and the people. What happens next?
The next thing would be to have a call with the private equity client to share your feedback and impressions offline, outside the presence of the target. Then you're going to have that due diligence call with the target, and preferably with their security team and others whose discussion is going to be germane to your assessment.
So Joe, what is that like, right? Because here you have the lawyer who's brought in specifically to help with cyber due diligence talking directly to the target company or the person who's going to receive the investment.
Yeah, it's going to vary case by case, Jack, and much of it is going to be driven by the relationship that the private equity client has with the potential target. And they will, in all likelihood, have spent a considerable amount of time with each other before you've gotten involved. So you follow their lead a bit, but by and large, it's going to be a cooperative tone on that phone call. You've got a target company that's interested in closing this investment. You've got a private equity client that's interested in trying to move things along. But that said, you have to be mindful, particularly as you ask questions about any breaches they may have had, that if you're talking to people on the security side who may have been present for some of these incidents, you need to be thoughtful about how you approach that with them so as to have a constructive but collaborative conversation. So after that due diligence call, you're going to have another debriefing with your client, share your impressions afterwards. And then this will depend on what the private equity client wants, but they may very well ask for some type of short memo that just documents the work you've done, the impressions that you have from having done this due diligence, and then also including maybe a list of 7 or 8 items for the private equity firm to keep an eye on as they move forward with the investment, particularly if they're going to have a board seat or multiple board seats. They tend to be very receptive to getting a punch list of items for them to keep an eye on now that they're going to be playing an active role in the company.
So that can be a punch list. Is it sometimes a memo? Maybe
Yeah,
you write it out?
Sure. A written memo or just an oral download. It's whatever the client may want.
And you've got a privilege attached to that, at least at that point.
You do. You got. It's important to be thoughtful there as a law firm working with your private equity client about you're sharing your mental impressions. It's attorney-client privilege. The target may have an interest in getting feedback from either the law firm or from their private equity partner. And that can be fine as long as all the parties are thoughtful about the way in which that feedback is conveyed and mindful that, whenever attorney-client information is shared with third parties, there's always the risk that there'll be a waiver of attorney-client privilege.
Right. And, my understanding is you do these things for a reason, right? These due diligence investigations or reviews. And sometimes you find things and they can be worked through, and sometimes you don't find anything, or sometimes you find things and you can't move forward. But, what is the risk if you don't do this?
The risk is, we come back to that Starwood Marriott example we had at the beginning, and I think, quite simply, the buyer may be buying or investing in a data breach. That was a high-profile case, and just a couple of weeks ago, the privacy watchdog in the United Kingdom fined Marriott almost 100 million pounds, which is over $100 million US, for this incident and the fact that they acquired Starwood, and in so doing acquired a data breach that Starwood had experienced for many, many years. And I think it was pretty instructive. The Information Commissioner in the UK said, the GDPR makes it clear that organizations must be accountable for the personal data they hold. This can include carrying out proper due diligence when making a corporate acquisition and putting in place proper accountability measures to assess not only what personal data has been acquired, but also how it is protected. That quote really embodies why this is such an important area.
All right, Joe, so what are the key takeaways for private equity decision makers from this?
Sure. Well, I think it's evident from this discussion and from that quote that cyber and privacy due diligence is essential to a private equity firm's overall due diligence before they make an investment. The law firm that is retained to conduct that privacy or cybersecurity due diligence can work alongside another due diligence team, other advisors who've been brought in to conduct what we might call more traditional due diligence. We've certainly partnered with other law firms before that may lack the requisite cyber and privacy expertise, and we can work hand in hand with them. And then ultimately, it's about providing value to the private equity client. Identify strengths and weaknesses. The weaknesses are important if this investment is going to proceed, because the client is going to need to keep an eye on those, particularly if they are gaining board seats. That may become a fiduciary duty issue for them in the future. And then, finally, the value ultimately of the investment is more likely to increase if they don't have cybersecurity and privacy concerns, or if they do, that they've been documented and addressed. And the final item I would just share is that it depends on the engagement. It's highly fact specific, but there may also be different ways for the law firm to structure the engagement with the private equity client, whether that is some sort of a flat fee or alternative fee engagement, depending on the circumstances.
All right. Thank you, Joe. And that was Joe Swanson from Carlton Fields, the practice group leader for the cybersecurity and privacy practice group here at the firm. And this is Jack Clabby. Thank you for tuning in.
You've been listening to Carlton Fields' podcast series with Jack Clabby and Joe Swanson. To learn more about our cybersecurity and data privacy practice, visit carltonfields.com. This podcast is intended for general information and educational purposes only and should not be relied on as if it were advice about a particular fact situation. The distribution of this podcast is not intended to create, and receipt of it does not constitute, an attorney-client relationship with Carlton Fields. Thanks for listening.